Okay, good afternoon and welcome everyone. My name is Michaela Parrish and I'm the Pro Bono Coordinator here at Morgan Lewis. So first and foremost, I just wanted to thank you all for attending today's training and also thank you in advance for volunteering your time to help immigrant cancer patients that are in need at next week's clinic. So before we get started, I just wanted to knock out a few housekeeping items. So this training will be recorded. So if for any reason you have to jump before the training is concluded, just send me an email and I'll be happy to send you the recording afterwards. This training is eligible for one professional practice CLE credit. So after this session, I'm going to circulate an email with the CLE certification sheet for you to fill out and return to me by this Friday, August 2nd, in order for you to receive credit. The email that I'm going to send will also include the client matter number for the clinic that you can also use for today's training. And please also be listening for the training's alphanumeric number or course code to include on your certification sheet, which our presenter, Julie, is going to announce at some point during her presentation. Julie is the supervising attorney at Legal Health, which is a division of the New York Legal Assistance Group that provides free legal assistance to New Yorkers who are experiencing serious or chronic health problems and financial hardship. Julie also coordinates the Cancer Advocacy Project, which focuses on specific disparities faced by people living with cancer, and that will also be the focus of today's training and next week's clinic. So with that, I wanted to thank you guys all again for your attendance and hand the mic over to our wonderful presenter, Julie.
Thank you so much for that introduction, Michaela, and thank you all for being here today and for volunteering your time next week. These clients are in incredible dire need, both from an immigration perspective and from a health perspective, because they are patients of cancer hospitals that we partner with. We are all incredibly grateful for your time, and it will be an invaluable help to them. I'm just going to share my screen. I have a little PowerPoint that I would like to show. Okay. All right, here we are. Michaela already gave a bit of an overview of what legal health is and what NYLAG does. But basically, we are a unit of New York Legal Assistance Group, which is a large nonprofit organization that provides free legal services. And legal health is a medical legal partnership where we partner with hospitals and try to bring legal care and medical care together so that we can help patients of hospitals feel better faster. This is a bit of my introduction, which again, I think Michaela went over, so I'm not going to go through that again. And basically a little bit more about legal health. We've been around since 2001, and we've partnered with medical professionals to address the non-medical needs of low-income people with serious health problems. Because access to justice is a universal right, irrespective of financial circumstances, the Cancer Advocacy Project specifically embodies this belief by offering free legal assistance to low-income cancer patients and hopefully alleviating the burden of legal complexities and allowing them to focus on their health and healing. One of these services that we offer is extensions of authorized stay for people who are here on visitors visas. And these are crucial to our clients because it allows them to remain in the US legally and continue receiving this life-saving treatment. So what is a visa? A visa is a travel document which is issued by the US Embassy and put into a passport of a person who wishes to enter the US. There are two types of different visas. There's the immigrant visa of people who are intending to reside in the US, such as people with green cards who would like to live here permanently as lawful permanent residents. This is not the group we're working with. We're working with non-immigrant patients who have a temporary status, which was issued to them either for business or for tourism. I would say all of our clients next week will be for tourism, so they will have B2 visas. But there are other types of visas that are for a temporary time, like students or temporary workers. This allows a person who is seeking admission to try to seek that admission in the border. And there is no guarantee that a person will be allowed entry because there are many other factors that go into what allows a person to travel to the United States, but it definitely allows them to at least seek that entry. It can be very difficult to obtain a visa. Visa applicants have to demonstrate their intent to return home and ties to their home country, including current employment, owning or leasing a home, and any family and community ties that they have. They also have to state that they will not take up employment in the United States, especially if it's not a work-related visa like the one we're working with, where it's simply for tourism, and that they will remain a law-abiding person during their stay, and that they do have an ability to support themselves, whether that's having their own money or whether it is having friends or family members in the US who are able to provide them with food and shelter, or someone in their home country sending them money to provide that for them. Why is this important for you to know about the visa application? This is important to know because these are all of the same factors that immigration will be looking at when they are deciding whether or not to give a visa extension. So it's kind of a similar process. This is what a sample visa looks like. This will be a page in a person's passport. It will state their name, where they're from, their date of birth. This is where it states the type of visa it is. So please pay attention to that when you're working with your clients. It should say B1 or B2. And then it will tell you the expiration date, the issue date and expiration date of the underlying visa. So most visas that are issued for a period of 10 years. There are some exceptions, but most of the time it's 10-year period. Now, this isn't the expiration date we're looking for when we're talking about the period of authorized stay, because even though a person has 10 years of a permission to enter the US and sort of travel back and forth, they only have a limited amount of time that they're allowed to stay in the United States. It's sort of not indefinite. Under B1, B2 visas, that period of authorized stay is about 6 months. So once a visitor arrives, they are inspected by CBP, the passport is examined, and all of visa documents are examined, and they might be asked about the purpose of their visit. If the visitor is found admissible and the entry is authorized to the United States, they will be allowed in, and sometimes they can be found inadmissible for many different reasons. Their entry can be denied, and they could be returned to their home country. When a visitor is found admissible, CBP will stamp their passport with a date of entry and expected departure. This is what we'd call the period of authorized stay. Like I said, it's usually a period of 6 months from their date of entry. This also creates an electronic I-94 record of entry or departure, which is stored in the database. This can be found online at this website by entering the person's passport information. This is an important record as well, because sometimes a passport is not stamped. Sometimes it's unclear because a lot of times the period of authorized stay is handwritten in, like it will be stamped with the date of entry, but the date of departure will be handwritten and it could be unclear. So a way for you to know exactly when that person is supposed to be leaving by and when their period of authorized stay expires would be to look up the I-94 record on this website. So you will be doing this for every client next week to kind of make sure that we know the exact dates. And also because we will need to include a printout of it with the packet that we will be mailing out. This is what a sample stamp looks like. As you can see, the date of entry is stamped, but the until date could be handwritten in, and again, could be not very legible. The CLE code is RUC 5432. Just going to leave this up for a minute so you could write it down. RUC 5432. I'll be repeating it again towards the end of the presentation as well. So visitors who have been inspected and admitted are within their period of authorized stay. It allows them to remain in the US for the purpose of their visa. So again, they cannot do anything else other than tourism if their visa is for tourism. And failure to depart before the expiration of this period can result in serious immigration consequences. This means they could fall out of status, meaning they can be subject to deportation, and it could mean an automatic revocation of their visa for future US travel. So for example, if they overstay that period and then go home to their home country and then say in a year would like to come back to the US, their visa may be revoked. The underlying 10-year visa may be revoked, so that they would have to reapply again because they have essentially violated the period of authorized stay and what is allowed under the visa. So when do we file extensions? It should be filed whenever additional time beyond the original period of authorized stay is necessary to complete the stated purpose of the trip. So let's say you were coming to the US and you wanted to see the Statue of Liberty, and for some reason it was closed for renovations, and you've decided that you can't leave until you see it. Technically, you can ask for more time based on this. The chances of approval for that are very slim, however, because usually the reason for approvals of extra time is for resolving an emergency situation. This is what we are arguing in our applications for an extension, is that our clients are sick and they need to resolve this emergency situation before they're able to come home. One question you may get from the clients next week is, why can't I apply for a year? Why can't I apply for a year and a half? Why is it only 6 months? Because they are granted in increments of 6 months. Extensions are granted in those increments. And unfortunately, if the person needs more than 6 months, they will have to apply again and again. We have had that happen with some clients. Some clients are applying for their second visa extension, and it can be granted. But I will say it is sort of a harder thing to have a second or third or fourth visa extension granted, because you're essentially arguing, I only need another 6 months to resolve whatever is going on. And then you're saying, I haven't resolved it yet, I need another 6 months. And it's, becomes a problem for USCIS to keep approving it. That's not to say they don't. We have had clients who have had, third and fourth visa extensions approved as well. Sometimes extensions can be granted for less because they are completely at the discretion of USCIS. So if a person, for example, is traveling back and forth many times, or this is their sixth visa extension and USCIS is getting very suspicious that they're just trying to live in the United States without officially applying for an immigrant status, they may say, we're giving you an extension for only 3 months. It is completely within their discretion, and there really isn't anything we can do about that, unfortunately. So who can apply for an extension? It's basically non-immigrants who currently have a valid non-immigrant visa. So the underlying visa that we talked about, that 10-year visa, it has to not be expired. That's one factor that you should sort of look at on the passports of the clients to make sure that that underlying visa is not expired. They have to have a lawful admission with this non-immigrant visa, which all of our clients should. They have not committed any crimes that render them ineligible for a visa, and they have not violated the conditions of admission. So for example, if they're here on tourist visa, they shouldn't be working. So that would be a violation of a condition. And they have to have a valid passport. Applying for an extension is a process. There are some forms that need to be filled out, and I will share them after we're done with the slides. I will show you the forms and sort of what they look like. What we will be working on together next week is completing Form I-539, which is the application to extend the non-immigrant status. There's also Form I-539A, which is a supplemental information for this application. This only applies if there's more than one person in the family that's applying. So for example, if let's say husband and wife are traveling to the United States to visit their family member, wife falls incredibly ill, goes to the hospital, and she's told she has cancer. And the husband traveled with her and needs to stay here in order to help take care of her while she's receiving treatment. The wife would do the application, the main application, Form I-539A, 539, and the husband would do the supplemental I-539A to be included with her application in order to also extend his authorized status and so that he could stay here with her. Again, all these forms will be provided to you, and I could share them with you at the end of this training. They would also need a check or money order for $470, a copy of the ID page of their passport. We don't need a copy of every single page of the passport. I know some immigration applications require that, but this one does not. We would also need a copy of the applicant's I-94. And again, if it's more than one applicant, husband, wife, children, anyone would need separate I-94s for each person. This is a piece of the I-539, which gets people confused very often. So I wanted to point special attention to that. And one of the questions it asks, what is the current non-immigrant status of the person? And it's a pull down menu. You can't type this in. And unfortunately, there's several Bs. There's more than 1B. There's B2, B2, 1A, and so forth. And you want to make sure that you're selecting B2, temporary visitor for pleasure. The expiration date that we're putting here, again, is not the date of the expiration of the underlying 10-year visa that you might see in the passport. We're looking at the date on the I-94 for the expiration of the period of authorized stay for that 6 months that we're talking about. And then we would be putting down how many applicants are here. So if it's only one person, we would be putting that. If not, members of the family are filing the application with me, and we have to put the number here. And so this date here, we request that our current status can be extended until, and this date would be 6 months from this date here. This also always causes confusion, and sometimes, you know, people put the wrong dates in terms of putting the 10-year expiration date here. So just please pay special attention to that. And I also recommend opening and saving a blank application on your computer and then filling it out with the client. We've had some issues where if you just open it and start filling it out, it doesn't save the information and you kind of have to start over and do it again. So if you could save a blank one first, that would be great. The next thing that is absolutely necessary for purposes of the application is a statement from the client, which addresses the following. We need to know the reason and need for an extension. We need to address the support or financial means that the person has during their term of stay. And if they do have a job, we have to discuss their ability to remain absent from work or their business, and whether or not their job might be available after a lengthy period of stay in the US. We also want to discuss any ties abroad, whether they, you know, own a home, whether they have a job, whether they have other family members that are waiting for them to come back. And we have to show a clear intent to depart after a term of stay. As you can see, a lot of these are similar to the conditions that we would have needed to prove when initially applying for the initial visa. So the standard is pretty high here. I'm going to share a sample of a personal statement, and we can sort of go over it together and see how it addresses all of these points. We also like to include any other relevant or supporting evidence. So we always include a detailed medical letter because, again, the underlying reason for asking for another 6 months for us is always medical because all of our clients are cancer patients. So we definitely want to include a very good and thorough medical letter. So we have told the clients to bring all of these all of the documents listed here the day of the clinic. They should have them all. If for some reason you're seeing that they didn't bring them or something is missing, please flag that for me. You know, in some cases, they didn't get it in time and we might have to wait, but I do want to know if anything is missing. So a sample letter would be also shown to you at the end of the training, just so you can see how detailed we want it to be. We really want to kind of explain the treatment plan and how this person could potentially feel better in 6 months, and explaining why they need to be here for that time, that they can't really get this treatment back home or they can't travel due to their medical condition. We want to also include any letters or statements of support from family and friends. And here I'm talking about financial support, really, to show that, you know, if someone isn't working, which they're not allowed to do while they're in the US, we want to know how they're affording their life, right? So if they're staying with a friend or family member, those people will be writing a statement explaining that they're providing room and board and, you know, any other additional financial resources. We also want to have copies of any financial documents. So if a person has you know, a savings account back in their home country, we ask them to bring those statements. If they own a home in their home country, we can ask for a deed. If a person owns a business documents and pay stubs, things like that. We need this as evidence of means of supporting themselves. Again, if this is all about sort of financial support and being able to live in the US without relying on any government benefits, really. Also, if a person was indeed traveling for a vacation, you know, and they, let's say, booked a week or a couple of months here, and they have a return ticket and they no longer can use that ticket because they're sick, but if they have that, it's a great way to show that they had intent to return home, that they weren't trying to sort of stay here indefinitely. So if they have a return ticket, it's great to include that. This is not an exclusive list. Sometimes clients bring other evidence documents, and we can sort of discuss them together. If they brought something that you don't recognize is on this list, we can see if it would be useful or if we can leave it out of the evidence that we're providing. So it's very important to file the application on time. They have to be received by USCIS before the term of stay expires. So whatever is that date on the I-94, the documents have to be filed before that date. USCIS often suggests that it be filed at least 45 days before the date of departure noted, but honestly, most of the time our clients don't even come to us within 45 days, and they're in the middle of cancer treatment and they aren't even thinking about this, and then they're like, oh, I'm supposed to leave in 2 weeks, and can you please help me with this? So some of the deadlines we will be working on are a little bit tighter. So we definitely want to make sure that we have everything we need on Thursday, on Wednesday next week. And so that way we can sort of mail this out as quickly as possible for the clients. Some important information and tips for filling out the application. So Form I-539, I-539A, and the applicant's statement have to be signed and dated originals. Sometimes clients will say, oh, can I take this home and read it with my husband and return this to you by email, or I'll fax it to you or I'll scan it to you. We really can't do that. We really need them to be original documents. We only need copies of any supporting documents. The USCIS very rarely requires any originals. So please make sure if clients are bringing you originals, we're making copies and we're filing that and including that in the packet. Any submissions in a foreign language have to be accompanied by certified English translation. That's something that's incredibly important. We often have clients bring us deeds or letters from their employer in Spanish or in some other language. We cannot include that without an English translation. So if you have documents like that and they're not already translated, we have asked our clients to bring them with a translation, but often they may not have been able to do that. Please flag this for us and we'll see if we can get them help with translating those documents. We usually file documents with certified mail and tracking to make sure that they're received. I will be mailing out all the documents. So at the end of the clinic, I will look over the packet that you've prepared and make sure sort of everything is there and nothing's missing. And then you will be giving me the original signed documents with evidence. We will be making a copy for the client so they can take that home for their record. And I will then be mailing out the original application. So you don't have to worry about the mailing part of this. So what happens after the filing? This is the question you may get from the clients you're working with. What now? So when this happens, an applicant will receive a Form I-797 receipt notice. Usually it happens within about a month. And the receipt notice basically states that we've received your application and we're processing it. It's not an approval or denial. It's just the fact that it was received. Sometimes an applicant can receive a request for evidence or an RFE. This often happens when additional information or documents are needed to make a decision. And this RFE has a fixed filing deadline. It is incredibly important for the clients to make sure that if they do need to respond, they respond by the deadline. Or if they respond later, it is usually denied. They usually do not get sort of more time to respond. If explanations have to be provided for any missing documents or unanswered questions. If there's some reason something can't be answered or can't be provided, they need to explain that in a lot of detail. And this is why we sort of attempt to provide the most complete initial applications when we're working together with the clients, so that we can avoid any RFEs, so they don't have to worry about this later. But you can tell your clients that if they do receive this request for evidence, they should contact the attorney that referred them to this clinic. So the NYLAG attorney that they were working with who made the referral, so that this RFE can be quickly addressed, and we can help them with that. That's not something you will be responsible for. This is what a sample receipt notice looks like, just so you know. Basically, again, it just says that this was received and this amount was paid. There isn't really much other information on this. It does give a receipt number right here, and a client can track how the case is going with this receipt number on the USCIS website. So that's something that could be useful to them if they're worried and they want to know what's happening. But most of the time, it will just say that the case is processing, and it doesn't give them, very detailed updates. So unless a decision was rendered, they won't really know much about what's going on until a decision is made. So a decision is then received either to approve or deny this extension. Denials are usually made by letter, and approvals are made on a similar form that looks like the receipt. And they would include a new form I-94, which has the new term of stay. So the I-94 should reflect the new, extended 6-month term of stay and the new date by which they would have to depart. And for approved applications, the new period of stay is retroactive to the expiration of the previous I-94. So even if, let's say, we file now and we ask for 6 months and the client doesn't receive an approval for the next 3 months or 4 months, it will be retroactive to the date that we asked for, from now until 6 months from now. Decisions are often issued late in the process. Sometimes it can take 120 to 180 days post-filing to receive a decision. This is also the reason why we make a copy and give a completed copy to the client. Because if they have to depart before that decision is received and they need to travel back to the United States at some point in the future, if they're stopped at the border and the officer asks them why they overstayed their initial period of authorized stay, they could say, I had to stay because I was getting medical treatment and I did apply for an extension. I just haven't received an approval or denial when I left. And they could show the completed application, and this could be a way for them to be allowed back into the United States if they need to re-enter at a later time. This is a sample approval, and on the bottom, this is sort of the new I-94, which gives a new date and an I-94 number and the person's name. Going to give the CLE code one more time. It's RUC 5432. RUC 5432. I would like to open it up to any questions, and after that, I'm happy to share the documents that we discussed so we can have a little bit more of an idea of what we will be working on together. Questions? Okay, no problem. So let me, I think there is a question in a moment. Okay, so Craig asks, if a person is not granted an extension, how long do they have to wait to come back to the US? So what happens when they're not granted an extension? They're sort of taking a risk by staying the time that they've asked for. So let's say they were supposed to leave by September 1st, and they filed their extension now in August, their request for the extension in August. They did it on time, and they're waiting to get approved. And now it's October, and they still haven't received an approval or denial. And it might be November, and they still haven't received an approval or denial, but they're still staying in the United States. And then later, the extension is not granted. Technically, they were illegally here for October and November if their original period expired in September. So they have overstayed their period of authorized stay and they have to immediately leave. And if they are planning on returning back to the United States at some point in the future, it is possible that they will be denied entry for doing that. That being said, I will say that I haven't had an application be denied in all of the time that I've been doing this, because most of the time they are incredibly good reasons why we're asking for the extra 6 months. So I haven't had that happen.
So I had a little bit different question. It's if somebody decides that at the end of the 6 months they go back in time before the time is up on their original length of stay, and then they want to come back, can they come back a day later because the visa is for 10 years? Can they come back for another 6 months just by basically going home for a day? Or is there like a whole new process that they have to apply to come back again? Sorry, that
Oh,
was
I
what
see.
I'm trying to get.
I see. I see. Sorry about that. Yeah. So that's a good question. Yes, they can technically come back after a day, but practically that shows to the person who is inspecting them at the border that it seems to CBP that they're trying to live in the United States, and that's what we're trying to avoid. So if a person is coming in and out frequently, that flags for CBP as a person who's sort of staying in the US too often. And what can happen if they're coming back so soon, if they are admitted, they could be given a less period of time to stay. So it might not be 6 months, it might be 2, it might be 3. And it's possible that they may be denied entry. We have had clients who've done something similar, maybe not a day, but they've stayed in their home country for a week or 2 and then came back and had absolutely no issues. So again, this is incredibly discretionary on the part of CBP and the agent inspecting the person. If you get like a nice person at the border, they have no problems with this and they let you in and out as, however many times. And again, we don't really have a way of knowing for sure what can happen. We advise our clients usually of all the possibilities and let them make that choice. Okay, another question. Oh, immunity issues with clients. So thank you for asking that. A lot of our clients are immunocompromised and we will be providing masks in the room. I would say you don't have to wear them in the outset, but the clients were instructed to let you know if they're more comfortable with you wearing masks as well. And they will ask you to do that if that's what they want. But thank you for being considerate of that. Stacy asks, I didn't understand your retroactivity point. From when is it granted the 6 months of the extension? So sorry about that. It is a little confusing. So the retroactivity is granted to when we're asking for the extension to be extended from. So let's say a person is supposed to currently, they entered and they're supposed to leave September 1st. We are filing the extension in August, but we're asking for 6 months from September 1st to October, November, December, January, February, March, till March 1st. So we file that application, but we wait for the approval for several months, and we don't get an approval until November. The approval will say, this application was granted, it was approved. You can now stay from September 1st until March 1st. So they're not getting 6 months from approval, they're getting 6 months from when the date they were supposed to leave. I hope that's a little clearer. Okay. Just gonna give it one more second if there's more questions. All right. All right, let me just stop sharing for a moment so I can pull up the documents that I wanted to show you. Give me a second. Okay. So this is the application, the I-539 form that you will be working on. One thing to also note, we are not listing ourselves as a representative. You won't be a representative for this client. This is sort of a one-time service. So you will not be filling out this box. You will not be providing Form G28 or entering your attorney number here. This is pretty self-explanatory in terms of name and address, date of birth, country, and nationality. You will be entering the I-94 number here, which you'll find on that website that I provided, and their passport number here. You do not need a travel document number if there's a passport number. And then the status, the B2 status is what I was talking about from this drop-down menu here. we need to make sure that we select the right one. Here, it will be an extension of stay in the current status. We're not changing status or reinstating student status. And here's where you'll be selecting members of the family if there are any applying with the person. The expiration of the new status, the new period of stay will be listed here. So that's that March 1st deadline that I just mentioned. Something like that will be here. This does not need to be filled out unless it's different from the first portion, which it shouldn't be. Physical address abroad, a lot of times it's can't be entered in the way that an American address is entered. I get this question sometimes where it's like, they don't have a street name and number the way that we do. That's perfectly fine. Just do your best to kind of enter however it can be entered. These questions should most of the time be no, because they would normally prevent a person from being able to receive a visa in the first place. So things like, have you ever been convicted of acts of torture or genocide? Clearly those kinds of things you want to say no to. I will flag this, that sometimes we do have people who, let's say, worked as police officers in their home country. So they may have had weapons training, for example. So this question could be a yes. If any question is a yes, you can then explain the situation of the reasoning why it's a yes. At the end of the application, you're provided with this page where it says additional information. And you could enter page number, part number, and item number and say something very simple like, in my home country, I worked as a police officer for 10 years, and as part of that had weapons training. Just a quick sentence explaining why the answer might be a yes. If you're using an interpreter, I think we might have one Spanish-speaking client. You would enter the interpreter's information here. And here you would enter yourself as the preparer. You can enter the firm's address as the mailing address, your contact information, and you will have to sign that here. If you are an attorney, you can say that your representation does not extend beyond the preparation of this application, so you will be checking this last box. If you are not an attorney, you can just click the box on top. So this is Form I-539. I-539A is very similar and a little bit shorter because, again, it's sort of a co-applicant, so they ask slightly less information. And it's kind of similar in what it's asking for. And you would enter your preparer's information and interpreter's information as well. Make sure that the applicant signs and dates it. This is a sample physician letter that we discussed. So as you can see, the physician basically explains what is happening to this child, what her condition is, why she must continue to receive follow-up treatments and monitoring, why she can't leave, because this procedure is going to take a specific amount of time. They explain that she's high risk, and they would like to ask for the extension of the parents' visas in order to be able to stay with the child, and the fact that they will be returning home, once the child feels better. This is a sample employment letter of a client who is employed in their home country. And it explains what the job is. Again, they don't have to be incredibly long or detailed. It just basically says that she's on a leave of absence with a duration of medical treatment and surgical treatments in New York, and they're expected to return and continue to provide services after the child gets discharged. So simple, but does explain what the situation. This is a sample letter from a friend or family member that explains that they're hosting the clients while they're getting treatment for their child, and they will continue to help them and provide them with support while they are here, while the family is here receiving treatment. I would like to draw your attention to the sample personal statement. This is the document we will be working on together. The other documents I just shared, the client should technically have already prepared and brought with them. I'm sharing them with you just so you can look over them and make sure that they are well written and kind of hit all the points that we discussed. And if they don't, please flag that for us. The statement, I just want to make it larger so you can see better. Okay, so the statement is going to be in this format. It's written from the perspective of one of the parents of this child that we mentioned. For our clients, some of them are, children, and we will be writing from a perspective of their parents, but most of them are adults, and we'll be writing first-person perspective. We explain why they're seeking this extension. Because they're receiving treatment, the child is receiving treatment. We talk about the child's condition, medical condition, and the kind of dates of surgeries and things that are happening and why she's required to stay here longer. He also talks about here that he's a business owner and he would like to continue operating his business. This is how he's sort of supporting himself. He talks about that his wife is absent from work, but she plans to return to her position as soon as she's able. They also talk about missing their family and friends, returning to their daily activities in their home country. This is important because we do want to convey an intent to return. And they talk about who they're staying with and how that person is providing them with room and board and any kind of support that they're receiving. So again, the statement doesn't have to be incredibly long. It just has to hit those points that we discussed. I will also be providing you with this. This is basically a checklist of how the documents should look and what we're looking for and sort of in the format in which we put the application together. The forms in red are the forms that you will be filling out and preparing a personal statement. Everything else the client should have with them, but you will be checking over to make sure that they have all of this information. And maybe we can have this printed for you the day of, so you can just have it on your desk while you're working and you can check off the information that we have. So these are all the documents that I have to share. And let me just make sure there are no further questions.
I did put one in the chat, Julie. The 539 form, those are the ones we need to have them sign there. So obviously we'll need to be connected to printers and be able to, because we fill it out online, you said, we don't fill it out in ink, they just sign it in ink.
Exactly. So we've worked with Namita and Michaela to make sure that we have printers available and there's like access to copy machines. So that should work on the day of. So you will be printing out the form I-539, any I-539As if there's family members filing together, and the personal statement. Those are the three forms that need to be signed in ink by the clients. Oh, and one thing to keep in mind, and I will check this, I'm not sure if we have any clients like this, if there is a child who is filing together with a parent who is over 14, that child needs to sign the form themselves. If they're under 14, their parent can sign for them. So that's something also to keep in mind. I'm not sure if we have any clients like that. I think they're actually all adults, but just to kind of flag that for you. And we will make sure that the child comes if they are over 14 so that they can sign that day off as well. Are there any other questions about anything?
I wanted to just mention something about logistics since we were talking about printing. Oh, is there, Peter asked, is there a color of ink that's preferred? We'll have pens there, but when they sign.
No, no, any ink is okay.
Okay. Very importantly, Julie will be there on Wednesday. So she'll also be, walking around able to answer these questions. We're going to ask that all the volunteers bring their laptop. For the most part, you'll be working in pairs. There might be one or two people, including anybody who's working with, a interpreter who it might be just the volunteer and the client and the interpreter. But please plan to bring your laptops and then work locally so that it's easier to print to the standalone printers. We'll have a printer reserved just for this clinic on the 39th floor. And you may be able to literally connect by plugging in your computer or just adding that printer to print. And then we'll have people walking around to make copies, etc.
Thank you, Namita. Is there any other question, logistical or technical or legal? Okay, I think then we could end for today. I thank you all very much for participating in today's training and especially for participating in this clinic. Again, these clients are very vulnerable and are incredibly grateful for this help because otherwise they would not be able to do this on their own. So thank you again very much. Michaela or Namita, is there anything you need to say, or can we just end the meeting? I'm not sure.
I think we've covered everything for now. We're going to be following up with the volunteers via email, and we may have some follow-up questions for you, Julie, in the meantime. But otherwise, we look forward to seeing everybody next week in person for this clinic on Wednesday.
Thank you, everyone. Take care.
Thank you.